At this time, I will call case number 126216, State of Kansas versus Matthew Lee Bibee Jr. And you can please correct me on the pronunciation.
May it please the court, Peter Meharry for Matthew Bibee, present and ready for argument, Your Honor.
Thank you, Mr. Mayor.
Good morning, and may it please the court. The state of Kansas appears by plaintiff appellee and Assistant District Attorney Kendall Kaut. We are present and ready for argument, Your Honors.
Mr. Count. Mr. Meharry, you may begin.
May it please the court, again, Peter Meharry for Matthew Bibee. If I could reserve 3 minutes of my time for rebuttal.
3 minutes is granted. Thank you.
This case comes before this court after my client was convicted of multiple offenses. It occurred over a weekend in Olathe, Kansas. The most severe charges were felony murder, attempted premeditated murder, and attempted capital murder. We raised several issues with regard to the trial and the criminal proceedings. And what I'd like to do is start with the first issue we raised in our brief, and that is whether or not there is sufficient evidence to support the felony murder. In this case, my client, as I said, was convicted of felony murder. He was originally charged with felony murder, with the underlying offense being aggravated robbery. After the preliminary hearing, the district court refused to bind over my client on egg robbery. At the state's request, it did bind my client over on attempted egg robbery. And that's what went to the trial, went to the jury. We believe that there is insufficient evidence to support the charge of attempted egg robbery in this case, because what you don't have, what the uncontroverted facts show, is you don't have a failure. You either have a completed robbery or no crime at all. We believe because they can't prove a failure in this case, they can't prove an attempt, they then can't prove that charge. And the uncontroverted facts that I referenced were that the property in question, and this involved a drug deal that went south, as they often do. But the property of the victim in this case, the backpack and the cell phone, were in the car with my client when they left the scene. The victim, after being shot, bolted out of the car, collapsed a short distance away from the car, and the car my client was in then left. The backpack, the cell phone, they were found several blocks away. They had been tossed out of the car at a later point. But what that shows is that, as I said, you either have a completed crime, they got the property, which we need for egg robbery, or it was abandoned.
I guess I have two questions, a factual question and a legal question about this argument. Let's start factually. What about the McDonald's gift card that was left in his pocket? I mean, why doesn't the statement from RK on who's talking to Mr. Bibee says run his pockets? Then there's an overt act in furtherance of a robbery. Why doesn't the fact that there's still property in his pockets when he said all right in response to running the pockets enough to show that there was an attempt?
Your Honor, first of all, that was never the state's theory. The state's theory was always that they was trying to take the backpack and the cell phone. And they have never.
The charging document just said property generally.
It does say property. But as far as run the pockets, that's not a literal phrase. That's a figurative phrase. That means to rob him. And what the state took from that is that he was trying to rob him of the backpack and the cell phone, which they got away with. And they never said, hey, he didn't get this. And that's the attempt. And what they did argue is he did get the backpack and the cell phone. And that's the completed robbery. So I don't think having just other property on his person, whether or not it be the McDonald's gift card or his shirt for that matter, is sufficient to support the attempted robbery charge here, because we have a completed robbery. If you look at it from basically the best perspective of the state, he got the property. He left with the property. And that, as this court has said in Hernandez, is mutually exclusive. Attempts and completed crimes are mutually exclusive. You can't have both.
And I guess that leads me into my question legally. Hernandez was really about focusing on the convictions themselves, right? You cannot end up with a conviction for both, right? But when we're talking about sufficiency, it's kind of an absurd result that the position is essentially the state proved too much, right? I mean, it's a lesser included offense, proof of a greater, don't we typically view that as sufficient evidence of the lesser?
Generally, if you prove first degree premeditated murder, you proved second degree intentional. So generally the lesser included are, in that tree, and as you move down the tree, you've proven them. But I think attempts are different because how attempts are defined in this state. Attempts require several things. One is an overt act, an intent to complete or try to complete the crime, and then a failure. You have to prove a failure. So when the state charged my client with attempted egg robbery in this case, they had to show that he tried but failed. And you can't show that if you show a completed offense. If you've completed something, you necessarily have not failed. So even though we're on a sufficiency standard, the idea that they're mutually exclusive still comes into play here. Because if you've proven a completed crime, you've disproven an attempt under Kansas law. So I believe Hernandez does apply in this case and does require finding that best case scenario for the state is that my client did a robbery. And it may sound odd. Hey, they proved a completed robbery, but they didn't prove an attempt. But that is the way the law is set up in this state. It's one or the other. You can't have both.
In January, we issued a decision in State v. Gomez. The issue there was an alternative means issue, so it's not controlling, certainly. But in that case, we really did break down the timeline and looked at when the when the murder happened versus whether the robbery was complete at that point in time. Does that same kind of analysis, and in doing so said that at that point in time, there was an attempted robbery, even if there was perhaps a completed robbery post-death. Does that same breakdown work when we're talking about felony murder?
I don't believe it does, because this court has said you have to prove the underlying felony. You have to prove each and every element of the underlying felony. So, if you want to really parse it out second by second, the problem I think you face is you don't really have either. So when there's this discussion or tussle or whatever's going on in the car, I would argue you don't have an attempt or a completed crime at that point, because you don't know the outcome. What we do know is had played out, my client left with the property. That is a completed crime. So I don't think you can say, okay, well, at this point, at minute 2 and 1 second, he didn't have the property. Then the victim left, and therefore, he was shot right then and there, and that's somehow an attempt. You don't have an attempt at that point because you don't have a failure. And that is what the state has to prove in this case. They have to prove that underlying felony, and they have to prove a failure to do so. And you don't have that until the events essentially play out. And as they played out, there was never any failure. That's why we believe that there is insufficient evidence for the underlying felony of attempted egg robbery. And as insufficient evidence to support that felony, there's insufficient evidence for the felony murder conviction as well, and they both need to be vacated by this court. With the few minutes I have left, I would like to touch on issue 4, and that deals with the exclusion of my client's father's testimony. During trial, my client intended to call his father about certain texts he received from my client Friday after the initial shooting, the drug deal shooting. The state wanted basically a proffer of some sort because they felt they had some objections to it. They did that, and the district court ultimately found that it was not admissible. One of the arguments the state made was that this was mental disease or defect type argument. And this district court seemed to have concerns about that angle as well. But it's our position that these texts, they were relevant and admissible. Mental disease and defect, you talk about the inability to form intent. What they argued below and what they wanted to put on was these texts that show my client maybe had intent to harm himself. So it wasn't that he couldn't form intent. It's that the intent was different than what the state was arguing as it related to the crimes later during the weekend.
Didn't the trial court basically not permit it because it was too speculative? Was that the basis? That's my recollection. You almost played into that by how you described it. Maybe suicidal, and it's one text. And if I'm sitting there as a trial court judge and this is offered, I think I would be weighing is there any other evidence to substantiate the kind of the suicidal ideations he was maybe trying to get into evidence? One text would be, in your mind, sufficient to raise that issue?
That particular point, Your Honor, relevancy is a low standard. And certainly one statement of a defendant is often enough. So I don't think the fact that it's just one text means, well, that's not enough. Relevancy is not about how much. It's just whether or not it has any relevance at trial. And certainly the text in question here, there were multiple texts sent to different family members, and they all, as far as speculative, all believe basically the same thing, that he might be looking to hurt himself, that he was on a downward spiral looking to do harm to himself. So I don't think it's actually that speculative either, that the father, when he got this text, what did he do? He called the police. I need your help to find my son. I'm afraid he's going to do something to himself. So I don't think, I'm sorry.
Oh, no, you can finish
I
your
don't think
answer.
it was speculative to the point where it's inadmissible. You can make inferences from it. What did he really mean? But again, relevancy is a low bar, and certainly everybody who got those texts thought the same thing.
My question is, I guess I have a little struggle with how we interpret and apply 215209, the mental disease or defect statute. And you suggested the evidence wasn't being used to show an inability to form intent. I guess the problem with that argument is our decision in Mastis, which interpreted the statute to not be limited to that type of use of mental disease or defect evidence, but instead it's, I'm quoting, it applies whenever a defendant seeks to prove lack of the required mental state as a result of mental disease or defect. And so even if you're saying factually, I was trying to do something other than intentionally murder a law enforcement officer, as long as it's connected to a mental disease or defect, the statute arguably at least applies. How would you respond to that, the Mastis case?
I don't think they ever made the argument that this is related to a mental disease or defect. They were arguing this is just where he's at. You know, he is on a downward trajectory here. He is looking to do self-harm. And his intent going into that Sunday when the other crimes occurred was not to kill, but to be killed. Now, I don't think that is delving into any type of mental disease or defect. You aren't saying he's thinking this way because of this mental disease or defect. You're just saying this is his intent. And we make decisions on intent all the time without bringing in mental disease or defect. So the argument they made below, and the argument that I think shows that this is relevant and admissible, is that this goes to his intent. And it's counter to the narrative the state is pushing at trial, that his intent fully was to kill. So it was key for him to be able to bring this into trial as evidence to counter the state's claims and the state's evidence. And we believe the district court, by saying no, none of this is coming in, undercut my client's ability to present a complete defense in this trial. If there are no other questions, we would ask this court to reverse for the reasons we've said in our brief. Thank you.
Mr. Cobb?
Thank you, and may it please the court. I'll start with the questions about whether there was sufficient evidence of attempted aggravated robbery, and then I'll turn to the questions about whether the evidence was relevant. I'm happy to answer anything within those issues that you all may have questions about as well. I think one thing that's helpful, though, when we look at this is that the state readily concedes in its own brief that there was sufficient evidence of an aggravated robbery, but under that sufficiency standard, there is also sufficient evidence of an attempted aggravated robbery. And here, the nature of the aggravated robbery statute can leave one rational jury thinking one thing and one rational jury thinking another. And so when we look at 215420, I can count 7 legal avenues that someone could think on a rational jury there is sufficient evidence, and that would be taking property by force while armed with a dangerous weapon, taking property by threat of bodily harm while armed with a dangerous weapon, taking property by threat of bodily harm while you inflict bodily harm upon a person, taking property by force when you inflict bodily harm upon a person. And then although we have ors in the statute, you could have both and still find it, and both and still find it, which adds up to 7, and I'll save some time in math by not going through it all. But the end result of those 7 options is that one rational juror could think, looking at the evidence, all right, we know Mr. Bibee is in the back seat of Juan's vehicle. When he's in the back seat, we hear from Juan's testimony that he hears a fabric moving. One rational inference that requires no inference stacking from that would be they're fighting over the backpack. As a result of that fight over the backpack, a rational juror could think he has his firearm out, so he's trying to take the property by force, and at that time he shoots the victim. In this case, he's attempting to take the item, but he hasn't completed that taking at the time, which would also substantiate some evidence for why later on, 2 days later, when the defendant, Mr. Bibee, tries to rob a different gentleman, Torrey Powell, at the Wingfield Apartments in Olathe, and we have State's Exhibit 145, which is that statement of Torrey Powell. He mentions both there and in his testimony at trial that he was told by Mr. Bibee when he won't hand over his keys or kick him his keys, I think the verb that was used, that he is told by the defendant, Mr. Bibee, the last person that said that lost his life. Well, that also leads to a reasonable inference for the jury that the victim, Mr. Cabello, does not turn over that backpack. He loses his life. So at the time he is shot, which satisfies that element for felony murder, the taking has not been completed.
Does that matter when we are dealing with felony murder, where we have the concept of res gestae of the so before, during, or after the felony can still satisfy the element of the crime. So can we break it down in that fashion because of the nature of this crime?
My apologies, Chief Justice Lukert. I think we can in this instance. I think to take a step back, and I want to make sure I answer your question directly about res gestate and what happens. What's a little difficult here is normally most of the time, I think when we get felony murders about aggravated robbery, it's aggravated robbery. There's the instruction of commission of the offense, which obviously would include attempt. And so here it's different. But I think on your specific question, Chief Justice Lukert, we can break it down because it is necessary, I believe, for Mr. Bibee's appeal to succeed, for them to break it down and say the taking is not completed. Or the taking is completed is their argument. Ours would be there's sufficient evidence the taking is completed. If that is the case within res gestate, it would be during the commission of an attempted aggravated robbery. It is the shot that kills him when they are fighting over the backpack that allows for that breakdown to occur. I would agree normally if it's just aggravated robbery, it's a lot easier question because it is a little bit ironic. I think as Justice Wall mentioned that they're saying we proved too much. We proved the completion of what would be a higher level crime on the sentencing grid. But because the shot that killed him to a rational juror could be when that taking is not completed, it would be during the commission of an attempted aggravated robbery that this felony occurs. And I believe that is sufficient, Chief Justice Lukert, under that analysis.
Would that be sufficient for the felony murder, but not necessarily the attempt? You know what I mean? Do you know what I mean?
Justice Wall, could you expound upon that to make sure I answer your question?
Well, I mean, if you're relying on the sort of the temporal scope of the felony murder statute, I understand your argument being that you can sort of press pause in the timeline, and as so long as the crime wasn't completed at some point within the temporal scope of the felony murder statute, it would be sufficient evidence. But then if you look separately at just the attempt charge itself, you don't have that statutory basis to sort of push pause, as I would understand it.
Yes, Justice Wall, under that line of argument for sufficiency, I would agree with your framing that there may not be the pause, which I think gets to what Chief Justice Luker's saying as well. So if I understand your question, Justice Wall, and I think I do now, and I appreciate that. Yes, there can be a pause for felony murder because it's just at the time that the victim is shot, that would be our act for felony murder to accomplish the killing. The property's not taken, so it's an attempt there. But if eventually he does take that property after the shooting, then it wouldn't be an attempt because there'd be a completion of taking of the property. I think there could be a distinction there, and that also leads into kind of our, whether it's a Punnett square, a Venn diagram of confusion we can get with this, where if it's just attempted ag robbery, I think you look at the time someone is shot, because that could be to a rational juror during the commission of felony murder. At the time he's shot, this is what happens. And to me, that relates back to the second question the jury asks, is this before or after the shooting as it pertains to the taking? So I think the jury really looked at this. I think they scrutinized it. And I think from that jury's perspective, they could say, at the time Bibee fires that shot that kills the defendant, he has not completed taking the backpack, or he hasn't completed running his pockets, or he hasn't completed getting his cell phone at that moment.
So you're saying the fact that he pulled the trigger and killed the victim is what prevented the completion of the crime under the statute?
Justice Biles, I'm saying under this version of the statute, at the time he has done that, he has not completed the taking. So yes, I would under that one. I think normally for an
It's not a question of completion. It's a question of it says, but fails in the perpetration thereof. So you're telling me that it's when he pulls the trigger, he's caused the failure.
Justice Biles, by pulling the trigger, he has caused the failure because it completes the ability to take the property. He would no longer be able to take the property under this framework, someone who's passed away. Normally, under the ag robbery statute, you could just have inflicts bodily upon any person in the course of such robbery, subsection 2 there, and then it would encompass that for a normal bank robbery if someone dies later. But when it's limited to just what I think will be a very narrow issue for this court, a judge has elected to bind over on attempted aggravated robbery. Most parties on appeal, and both parties here agree, it could be an aggravated robbery, but you only have attempted aggravated robbery. Could any rational juror make that legal conclusion from how they are instructed? And that would be our argument, that some rational juror could look at this, draw that legal conclusion from what is a confusing instruction about felony murder with attempt, and come to that conclusion. And that would be the state's position.
What should we make? What should we make of KSA 21-5109B, which makes attempts lesser includeds of completed crimes?
So Justice Stiegel, along with your question, I think what Justice Wall's getting at, I think eventually the day will come where the state does full briefing and says, we've gotten to what we believe is sort of a ridiculous point with the legal outcome, where the defendant can come up here and say, I did a worse act under the Sentencing Guidelines Act, but I should escape legal penalty.
And I understand the practical absurdity, if you want to call it that, but I'm thinking more of the legal impact. I mean, typically we think of lesser includeds as crimes that are included within the greater. Here we have crimes that are mutually exclusive, or at least that's what we've said. But we have a statute that says it's a lesser included. Does that legally create any impact on this argument?
So Justice Stiegel, I think because of the nature of the statute with aggravated robbery, it does not create a problem here. I think for the—
Well, I guess, let me put it bluntly. Does it help you?
Justice Stiegel, I think it can help the state.
How?
The way I think Justice Stiegel it could help the state is saying, because it's a lesser, if you prove the higher with things like the skip rule, things like the pick instruction about if you prove a higher culpable mental state,
would it be essentially a bit of a legal fiction that almost feels a little bit like a harmlessness analysis.
I think it does, Justice
Is that
Stiegel.
plausible in this kind of a case?
Justice Stiegel, I think it is, and that was our final section of this, and why this sort of exists outside of the due process 14th Amendment concerns about you have to prove each and every element to the jury. Well, the state here proved more than each and every element to the jury because it proved what would be a higher degree of that crime. And so that's why harmlessness should come in here, because the substantial rights of the defendant, the due process rights of the defendant, are not harmed here, where the state has proven more than just the regular attempted aggravated robbery.
Well, what prevented you from charging or arguing aggravated robbery? I appreciate he was bound over because the judge felt it was only an attempt, but you could have charged it, you could have recharged it, you could have argued that, instructed on that. What prevented you from doing that?
Sure. So Justice Biles, the state filed a motion for reconsideration, or excuse me, Justice Rosen, the state filed motion for reconsideration. Without your glasses,
Who's going to take offense?
without the glasses, Justice Rosen, it's thrown me off. I apologize. But Justice Rosen, in this instance, because the state filed a motion for reconsideration, we had the COVID pause, so we have a long delay in getting to trial. The state then maybe has an option to, does it want to appeal one count and a multi-count complaint for somebody who either did or attempted to murder 3 people in our community? So that really limited it. And the state continuously said, we want to present aggravated robbery. Here's why this happens. And so ultimately, we feel like the state did more than is sufficient to say, we tried our best. We had it in the final complaint going to trial, and the court just continuously said, I'm not going to instruct on that. I won't allow it. If there are no additional felony murder questions, I did want to turn to the mental disease or defect question and relevance.
Well, can I just ask real quickly then, is there any possibility that in the legislature's definition of attempt, that the language about not being complete is really just sort of surplusage, especially given the statute that Justice Stiegel mentioned that on the lesser included offense? I mean, that would be consistent to interpret it, if there's ambiguity in the attempt statute, that it's really just the intent to commit the underlying offense plus an overt act in furtherance, and the other language potentially is descriptive and not truly intended to be an essential element. But that's not what we've said historically. Is that part of your argument, or?
Justice Wall, I think that is a possible pathway to the ultimate goal the state has in this appeal. I don't think that is a pathway the court must travel, but that would be a pathway that the state would be comfortable with the court traveling. As it pertains to mental disease or defect, I think these 3 questions are intertwined. Is it a mental disease or defect? Is it relevant? And if it is relevant, well, would it survive harmlessness? Because it is, as Justice Rosen had mentioned, merely one text message sent to his father 2 days before the attempted capital murder. And so in this case, from what I understand from the Bibee brief, they are only attempting to argue that the suicidal text, or their attempted suicidal text in their viewpoint, pertains to he did not have the intent or premeditation to kill Officer Matthew Fletcher. But this is one text 2 days before. And so to say he is suicidal on that Friday the 29th, and then he's suicidal 48 hours later on the 31st, to me would support, well, this is more than just a run-of-the-mill ideation that comes across your head. This is that mental disease or defect. And in fact, on cross-examination, Ms. Shannon, during the proffer of Mr. Bibee's father, had mentioned, well, is this based on bipolarness? Is this based on a bipolar disorder, which clearly would be a mental disease or defect? And it would be a very hard line to draw for what happens. But beyond that, with harmlessness here, it's quite challenging when the state presents evidence from State's Exhibits 137 to 140, which includes the direct body cam footage of Officer Fletcher, the in-car camera of Officer Fletcher, and you can see Bibee shifts from his non-dominant left hand to his dominant right hand with the firearm. If his only goal is suicide by cop, why does he move the gun to his dominant hand? If his goal is suicide by cop, why would you shoot at Officer Fletcher multiple times?
Doesn't that just go to harmlessness?
Justice Stanbridge, I think it does.
Because at the time they wanted to submit it or introduce it into evidence, that hadn't come in yet, right? That evidence hadn't.
You are absolutely correct, Justice Stanbridge. In the record, it had been rejected after that proffer. And so that is a harmlessness analysis under that prong. I think they're intertwined in a sense that If it's clearly so harmless, it would relate to why it's not relevant because it doesn't bear on that ultimate issue. If the evidence is overwhelming, that it's premeditated based on the nature of the shooting, moving from one hand to the other, based on him having his hood up on a March day when it's sunny outside, he is trying to conceal himself. And when he gets the opportunity for law enforcement to correct him, contact him, and put him away, he moves the dominant hand, shoots multiple times, and nearly ends Officer Fletcher's life.
If a defendant took the stand and just testified, I was down in the dumps, I was feeling like I didn't have any options in life, so I wanted to induce an officer shooting because I didn't want to kill myself. Or maybe even don't say kill yourself. But if that was the testimony, it seems to me that the mental disease or defect statute wouldn't be in play at all. It would just be direct evidence of intent that was contrary to the intent required for the crime.
Justice Wall, in that situation, that may be the case. And in fact, Judge Ryan had even mentioned, well, if the defendant takes the stand, that could change the analysis. Because it's a down in the dumps, that could change the analysis from there. But I would certainly agree with you, Justice Wall. That's a much closer call, and that probably does get over the line, as opposed to just 48 hours earlier, there was a text sent to his father.
But I guess I'm wondering, what is it about this proffer that makes it fall within the mental disease or defect statute? Is it just the references to the father saying, hey, he's had suicidal ideation in the past? It's the suicidal content, right? Is that what gets it in the statute from the state's perspective?
So Justice Wall, that would be sufficient from the state's perspective. If this court feels that it's too broad, I think the temporal nature that it's 48 hours earlier would also cause you to have to say there's something there more than just he was suicidal 48 hours earlier. It would have to be based on a threshold of mental disease or defect. So I think those are two avenues if the court feels my original answer is a little too broad. And Chief Justice Lukert, I can see that I'm out of time. So if there are no additional questions, we would ask the court affirm the ruling of the jury in the district court in this case.
I see no questions. Thank you.
Thank you.
Mr. Meharry?
Thank you, Your Honor. I'll make just a couple quick comments about exclusion of defense evidence. Then I'd like to make a few comments about sufficiency. One, opposing counsel talked about essentially all the evidence showing intent to kill and how that was overwhelming. I would point out the trial evidence is more overwhelming because defense counsel couldn't admit their evidence. So it wasn't exactly a fair shake in our view. Second, the state talks about, well, this happened 48 hours before. This happened the Friday. The shooting at the officer happened on Sunday. I would point out the state in its brief argued, quote, intent can be informed from his crime spree over the 3 days. That's from page 37. And I think that's exactly right. You can look at what transpired over that 3 days, and it was relevant to what transpired on Sunday. As to sufficiency, I actually brought up the statute book. Attempt is an attempt is any overt act for the perpetration of a crime done by a person who intends to commit such crime but fails. Failure is in the statute. This court all the time assumes legislature doesn't just put extra words in statutes. They put it there for a reason, and they put it in the attempt statute. And that's why this court has said you cannot have an attempt and a completed crime. Attempt is a failure. Completed crime is just that, a completed crime. It is successful.
Let me ask you a couple questions about that. I completely understand your argument on sufficiency for the attempted ag robbery. But it seems everyone just makes a leap that if it's insufficient for the attempted ag rob, then the evidence is insufficient for a felony. But I would characterize the arguments here as everyone agrees that the evidence is sufficient to prove the elements of felony murder. Do you think that the evidence is insufficient to prove? I mean, you're here saying my client committed an aggravated robbery. An aggravated robbery is an inherently dangerous felony. There was a killing committed in the course of it. Why isn't that sufficient?
There are two reasons why I would say that's insufficient. Number one, and this goes to State v. Stewart, which came out last year. This court said, quote, "The state must establish all elements of the alleged underlying felony to successfully prove felony murder." And in this case, the underlying felony was attempted ag robbery. To prove all elements of attempt, they had to prove a
So
failure.
even if there is sufficient evidence of a different inherently dangerous felony, that's somehow not included.
That is not included. And I would say the second thing.
And
I
is
would
your,
say
are you relying solely on that one sentence from Stewart to arrive at that conclusion?
The other reason why I don't believe you can say, well, they committed a different inherently dangerous felony. My client has a right to notice to what he's been charged with. The state can't
Right,
say,
so-
I'm gonna,
And I appreciate you're going there, but I know we're short on time, so I'm
Sure.
sorry to interrupt. But yes, where you're headed is there may be other legal problems with going that route. Due process, jury instructions, there may be others that we could think of together, but they're not sufficiency problems, right?
they are not necessarily sufficiency
So
problems.
wouldn't they be subject to a harmlessness analysis? That's where I'm ultimately that's what I ultimately wanted to ask.
I guess I don't see how you're gonna separate that and say, well, okay, he didn't commit the underlying felony that he was charged with, that the jury was instructed on. But we as a court are gonna find that there was sufficient evidence of this other inherently.
Well, you're
dangerous.
arguing that there is. That's your entire argument.
I'm
There is
arguing that-
sufficient evidence, which as a matter of logic eliminates or renders evidence of the actual alleged crime insufficient. You're asking the court to reverse on sufficiency, which means he's not going to even be retried
Correct.
for this killing, which everyone knows happened in the course of an inherently dangerous felony.
And the state had the opportunity to charge it any way they wanted. They have virtually unfettered discretion in charging. And what did they do? They went full steam ahead on attempted egg robbery, and there is insufficient evidence of that. And it can't be upheld by this court because we, now judge and jury, are finding that he committed a different inherently dangerous felony.
Well, go with me for one more question.
Sure.
If we were to agree, and big if, I understand that there was sufficient evidence for an uncharged, unalleged, different inherently dangerous felony, would you agree that that means that purely on a sufficiency basis alone, there was sufficient evidence for the felony murder conviction?
I would say you can't say that because that's not what the trial was on.
Okay.
You have to look at it. What was the charge? Is there sufficient evidence to support that charge? And here the answer is no.
What do you make of the fact, I mean, the jury asked that question in terms of what failed meant in the context of an attempted aggravated robbery of RP, and found that, and asked a second question regarding whether he knowingly took property from the person or presence of RV refers to before or after the shooting. The jury wrestled with that issue like we are, and ultimately concluded he was guilty of that. What do you make of that?
I would say mainly it's very hard for a jury to acquit when there's a 17-year-old kid who's dead. And I think what they struggled with was, this is an egg robbery. This is not an attempted egg robbery, but we only have one option. They asked, are there lesser included of felony murder? Which there are not under the law, and the court told them that. So I don't think that staves the state's case, because you still have to look at the evidence and whether or not it proved the charge the state brought and put to a jury, and it did not.
Chief, if I may ask one more question, maybe returning to a question Justice Stiegel asked. You read to us the definition of an attempt under the statute that included the failure to complete the crime. How do you reconcile that, or how should the court reconcile that with the lesser included statute that says an attempt is a lesser included offense? I mean, does that create some ambiguity?
I don't think it necessarily creates some ambiguity because I think, and I've cited in our brief, and they were both State v. Brown, by luck of the draw, where this court looked at the evidence and said, that could be attempt, that could be full on, whatever the felony was. So I think an attempt is a lesser level, obviously in terms of severity. And it is one of those where sometimes we are not sure if the crime was completed. And in those instances, what the legislator is saying is attempt is a lesser that should be considered and instructed.
And then we just ignore included then in that context? I mean, yeah, it's lesser, but is it included within a completed offense? It's really not.
Well, I guess I don't see it as, I know it's, we at times talk about like nesting dolls with lesser. I guess I don't see that as, when we say included, I don't think we necessarily mean, okay, well, one fits in the other, one exactly fits in the other. I think it is, okay, these are crimes that are alongside these other completed crimes, because sometimes we have that ambiguity in the evidence where we're not sure. So they're included because we want the jury to be instructed on both. We want the jury to make those factual findings. And then obviously, you know, we as judges look at it to see if there's sufficient evidence. So I guess, I don't know if that made any sense, but I don't think necessarily included language means identical, because they have a separate subsection that talks about where all the elements are the same. Or it's, some of the elements are identical to the one above. So I don't think included necessarily means it has to be the same. With nothing further, again, I would ask this court to reverse for the reasons we've stated in our brief. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will now take this matter under advisement.